From the PEP Radio Newsroom, we have another idiotic decision from the majority of the U.S. Supreme Court. The Supreme Court on Monday blocked California from enforcing a policy that restricted schools from informing parents if their child expresses gender nonconformity or attempts to change their name or pronouns. The ruling in Mirabelli v. Bonta, a case on the court's emergency or shadow docket, centered on children's expression of gender in schools. In an unsigned opinion, because they're all a bunch of spineless bitches, the court reinstated a lower court's ruling that would allow schools to inform parents about their children's gender expression. However, the opinion was not unanimous, thank goodness, as is the norm for unsigned opinions. Instead, it appeared split 6-3 along ideological lines, with all three liberal justices dissenting and the morons siding with the majority opinion. The parents who assert a free exercise claim have sincere religious beliefs about sex and gender, and they feel a religious obligation to raise their children in accordance with those beliefs. California's policies violate those beliefs, the opinion read, which is a bunch of bullshit. The court also cited its own previous decision in Mahmoud v. Taylor, which allowed parents to opt their children out of elementary school curricula that include books with LGBTQ plus themes, which is still a screwed-up decision. The case challenged a 2024 California law that states public school employees do not have to disclose any information about a student's sexual orientation, gender identity, or expression to anyone without the student's consent, as it should be. The law, signed by Democratic Governor Gavin Newsom, was the first in the nation to ban forced outing policies in schools, in contrast to a slate of anti-trans laws in other states, such as Mississippi, Alabama, Arkansas, etc., that require schools to inform parents about a child's gender identity, which is not their parents' business. The ruling noted specifically that while it only granted the reinstatement on behalf of parents, the lawsuit also claimed the policy violated the free speech rights of teachers by prohibiting them from informing parents. The justices were split. What about the children's rights? Don't they get any? No, of course not. This is the United States. Justice Uncle Ruckus and Samuel Alito would have granted it in full for all parties, while Justice Sonia Sotomayor would have denied it in full, thank goodness. Meanwhile, Justice Amy Coney Barrett wrote a concurring opinion, joined by Chief Justice Dingshit John Roberts and Justice Brett Kavanaugh, who has no brains, while Justice Elena Kagan wrote a dissent, joined by Justice Ketanji Brown. So our question to you is this: when kids get kicked out of their bigoted parents' homes in California, do you suppose Justice Brett, I got feathers for brains Kavanaugh, will take them in? No. Maybe Justice Uncle Ruckus will let them sleep on their back porch. Hey, who am I kidding? He's got cotton to pick in the morning, like the good old days he remembers. From the PEP Radio Newsroom, I'm David Moore.